Most UK websites have terms and conditions, but what most founders get wrong is what those terms actually protect, and where the real risk still starts in 2026. This video explains what free website terms do, where they stop working, and when relying on them alone becomes risky for a UK business. Website terms and conditions are a legal framework, not full protection. They set the rules for using your website, define who you are and who the user is, clarify that your service is informational, not legal advice, and establish England and Wales as the governing jurisdiction. That framework matters, but it doesn't solve everything. Free website terms are usually suitable for early-stage UK websites. Think informational platforms, MVPs with limited user interaction, and non-regulated low-risk use cases. They're designed for businesses testing ideas, not yet relying on users, payments, or automated decisions. At a basic level, free terms help stop misunderstandings early. They define the parties, explain the nature of the service as informational, outline user obligations, and clarify account responsibility. This helps set expectations, but it doesn't remove risk. Free terms usually don't exclude non-waivable rights. Liability is often limited to foreseeable losses, and fraud or personal injury is not excluded. Importantly, liability wording is typically subject to applicable law and fairness requirements. Courts look at fairness, not just what's written on the page. Free terms commonly acknowledge UK GDPR and reference the Data Protection Act 2018. They often state that the platform acts as a data controller, but this depends on how and why data is processed on the site. Privacy and cookie notices apply separately, and terms and conditions do not replace a privacy policy. These terms usually confirm that platform IP stays with the provider. Users receive a limited license for personal or internal business use only, with no resale or redistribution. A common mistake is assuming users automatically own generated content outright. Ownership and licensing need to be clearly defined. Free terms typically prohibit unlawful use, IP infringement, misrepresentation as legal advice, and system interference. Enforcement powers exist, but they're usually limited in free versions. Users can usually stop using the service at any time. Platforms may suspend access for legal or security reasons. Notice mechanics are basic, and control during disputes is limited. Free terms usually do not include defined liability caps, business user protections, subscription or renewal controls, dispute resolution mechanisms, or advanced enforcement rights. These gaps matter as your business grows. This is where problems usually start for UK websites. Refund disputes, where expectations aren't clearly set. Platform misuse, because acceptable use rules lack teeth. Increasingly, claims based on reliance on AI-generated outputs. And consumer cancellation confusion, where rights aren't clearly explained or are misunderstood. These issues don't always come from bad intent. They usually come from gaps in how risk is structured and communicated. The free version provides core compliance for informational use with limited protection. A professional version is typically designed to align with common UK consumer protection requirements, including modern reforms. It adds liability caps, subscription controls, and stronger enforcement tools, depending on your use case. Free terms are often enough when a site is static or informational. There are no payments or subscriptions, no AI-driven decision-making, and low user dependency. Early stage doesn't mean no risk, just lower exposure. Risk escalates quickly when a business introduces SaaS tools, AI features, subscriptions, user-generated content, or commercial reliance. This is where disputes typically form. Free does not mean full protection. Terms allocate risk. They don't remove it. Fixing legal structure late usually costs more. Structuring early saves time, stress, and disruption. This content provides general legal information only and is not legal advice. Founders remain responsible for ensuring suitability for their specific use case. Thanks for watching. To learn more about UK-ready website terms and compliance frameworks, visit doggitlawyer.com.